Hi, everyone. Just wanting to make sure that you can see me and hear me. And maybe in the Q&A, if you could just let me know. We're just going to give it a couple more minutes and let a few people in, and then we are going to get started. Awesome. I see some thumbs up, so thank you. A couple more coming in there, so we'll give it one more minute. 6:05, let's start. Okay, 6:05. I think we'll get started. I think people will just come in as we move along. We wanted to get this started for everybody, so we have lots of time. So, hello everyone. My name is Marcia McMurtry, and I'm the Director of Development here at BCSF. Thank you so much for joining us for this Wills, Trust, and Estate Planning presentation. I would like to start by acknowledging that we are very grateful to be virtually gathered on Indigenous land. From our offices in Vancouver, we are grateful to be on the traditional, ancestral, and unceded territory of the Coast Salish peoples, including the territories of the Musqueam, Tsleil-Waututh, and Squamish nations. I will join Grant a little later in the presentation to give you information on including wills in your will, including gifts in your will. But before you hear from us, we have an informative presentation to share. As many of you know, estate planning is a complex topic, even more so when planning for the financial future of a loved one with a mental illness. It is something that most families do not have a lot of knowledge about, and that is why it is important to seek professional guidance. Our hope is that this seminar will increase your understanding of wills, trusts, and estate planning, and offer guidance for making estate arrangements for yourself and a family member. Having a mental illness or having a family member with a mental illness drastically increases the importance of having documents that can take effect during a lifetime. Ben will explain those types of documents and which ones are beneficial to have in place. We recognize that many challenges are faced by families with a loved one with mental illness, and our mission is to support families. So we do hope the information you will hear today will be helpful. So let's get to it. Ben will begin in a moment, and after Ben, Grant and I will finish the presentation, and we'll have time for a Q&A session. And we would really like to hear from you, so certainly put your questions in the Q&A box at the bottom of your screen. We will make every effort to address all of your questions, and if we are unable to do so, we'll do our best to respond to them after this event. Please let me introduce our speaker, Ben. Ben has over 5 years of experience in the legal industry, and his previous practice experience has allowed him to become well-versed in estate planning tools and strategies. During that time, he assisted numerous clients to develop comprehensive estate plans that fit their individual needs and goals. Ben takes pride in guiding clients with ensuring that the necessary planning details are in order for the smooth eventual administration of their wishes. Ben facilitates the process for individuals seeking to appoint Solus Trust in any of our offered fiduciary roles. In this process, he works collaboratively with law firms, investment advisory firms, accounting firms, charitable organizations, and seniors organizations. Ben holds a law degree from the University of British Columbia and a Bachelor of Arts in Theatre from Trinity Western University. Thank you, Ben, for being here.
Thank you very much for having me. Okay, let me share my screen, make sure we get the presentation version of this slideshow. All right, does that look like the right one? Okay, fantastic. Thank you very much for that introduction, Marcia. I'm absolutely delighted to be here today and to be able to chat with all of you a little bit about estate planning. So I am presenting today on wills, trusts, and estate planning. I presented at a conference a couple months ago, and the prompt that they started with for all of the speakers was tell a fun fact about yourself. And my fun fact is that I did and won a novice trampolining competition when I was on exchange in law school in Scotland. So if that humanizes me a little bit more than just the lawyer on your Zoom screen for this evening, then wonderful. So like Marcia mentioned, I work as a senior trust advisor at Solus Trust Company. I will get into a little bit more about what trust companies are and how they work and what we do. But before that, I worked as a lawyer in private practice, doing estate planning and estate administration, assisting with trust planning. And I very much can appreciate that estate planning is a complicated and stressful process. So my goal is always to make that as sort of straightforward and understandable as possible. So hopefully I can address any of those questions that you have at the end of this as well. All right. And as a lawyer, I do have a disclaimer. So this presentation is for general information only, shouldn't be construed as specific legal advice for you. I like to say there's no such thing as a simple estate or a simple estate plan. So always very good to get your own legal advice and incorporate the advice of other professionals that you also work with. Financial advisor, accountant, all of those people can be really important parts of a comprehensive estate plan. So a bit of an agenda for this evening and what I'm planning on covering. So starting at the very beginning, I'm going to talk about estate planning, give an overview of what that is, what the basic pieces of estate planning look like in British Columbia, and then some planning considerations and risks. Then we'll hop into trust planning, which I think is a very big piece of planning for a lot of people on this call this evening. Talking a bit about the Ministry of Social Development and Poverty Reduction and the PWD regime in British Columbia, and how that affects trust planning, and then some different types of trusts and what works and what doesn't in terms of continuing to meet those requirements under the regime. And then finally, some mechanics about making the trust work, how trust operation functions, including looking at choosing your executor and trustee, looking at testamentary trust planning, as well as sort of questions about access to funds and mechanics. I won't have time tonight to go into kind of all of the bits and pieces and details of how a trust operates once it's been funded and operational, but we can address some of the overview and the basics of that tonight. So first off, estate planning. What is estate planning? It's a great question. I think it's something that, especially when you've been in the sphere for a little while, it's easy to get lost in terms of saying, oh yeah, estate planning. That's just all part and parcel of it. So really, estate planning is the organization of your financial affairs to benefit specific persons, organizations in the event of your death and or incapacity. It gives direction with respect to your assets as of the time of your death, specifically in your will. And in terms of planning, it's always very important to ensure that your plan is updated and current and that you're organized, both in terms of the plan and in terms of the supporting documents and information that your named executor and trustee would need. I will pass along a little anecdote, which is if you have done planning in the past and have not done it in a while and are overdue, you are very unlikely to be overdue than the longest update that I ever had when I was working as a lawyer. I once had clients who came in and said, should we bring in copies of our old estate planning documents? And I said, sure, bring in your wills. They were typewritten wills on a typewriter, and they were 50 years old. So the clients were well into their 80s, and these wills still had guardianship provisions for minor children. So a few things had changed in their lives since then. So good to stay up to date and current if you can. I understand it's a big undertaking sometimes, so never feel like you can't go and get an update because it's been too long and you're embarrassed for that. So the basics in British Columbia. I like to sort of talk about estate planning and the basic estate planning documents with this bright line down the middle. So the bright line is when you pass away. So once you've passed away, the only document that really matters is your will. So the will governs who is going to be managing your estate for you, how that estate gets divided, and provides them with instructions on how to do that. Before you pass away, though, there's other important documents that are what we call incapacity planning documents. So that's the power of attorney, which is naming someone to manage your property and finances for you, and your representation agreement, which is there specifically to allow someone to manage your personal and medical care decisions for you. So sometimes those two work closely together. Your power of attorney might be paying the bills for the care residence that you live in if you're incapacitated, but your representative gets to decide where that is. So it can be a bit of a collaborative approach. The advanced directive is on here because I have been seeing it used a little bit more frequently in the past year or two. An advanced directive is not naming someone, but it's providing a set of instructions for a medical care provider on your thoughts and feelings about end of life care, so a DNR or something like that. And so in the work that I do for a trust company, we're able to assist and wear a bunch of different hats. One of the ones we can't is we can't act under representation agreements. So I sometimes have people who come to me who say, I don't have anyone else to act in this capacity. I've got my spouse, and then after that, there's really no one else who could make these decisions. And so an advanced directive is a way for them to make some medical decisions and put those medical decisions basically on the record to their healthcare provider so that they're there in the event that they were ever needed. Now, of course, nothing is ever that simple, so there are plenty of other planning tools and distribution options when we talk about estate planning. One of the biggest ones is inter vivos trusts. It will specifically delve into trusts, as I mentioned, further in the presentation. So if you're already confused on the trust side, no problem at all, just put a pin in that. But there's a variety of different types of trust options. There's alter ego, joint spousal, family trusts. And so assets that get settled into the trust would stay there and they would go and get distributed in accordance with those trust terms. They would not fall into your estate to be distributed. So also notably, if you have assets with beneficiary designations or assets with joint ownership with the right of survivorship, those assets also fall outside of your estate. They wouldn't be governed by your will because they go directly to those beneficiaries. And I'll talk about that a little bit more in a slide or two. So one thing I thought would be helpful is sort of just walking through what are these steps of estate planning. If you're starting from scratch, what does the process look like? So first off, you've got to start with pre-planning. So some of this can be done with a lawyer, with an advisor, but really the two big pieces that you need to start thinking about are getting an idea of what your assets look like, your assets and liabilities. Are assets passing outside of your estate? Are they going to go directly to beneficiaries? And what those pieces are. And then the other is, who are the key people? What does your family tree look like? Who are the beneficiaries? Who's their executor going to be? And so kind of think about those things. Then you really start with the planning process. So then you need to work with a lawyer. In British Columbia, for estate planning purposes, estate planning can be done by both a notary and a lawyer. However, notaries are limited to only doing trust planning for minors in a very simple way. So for a lot of people here who are doing more complicated trust planning, you will need to work with a lawyer to get that drafted. And then also retain other advisors as needed. If you've got other advisors, if you've got an accountant or a financial advisor, it may be helpful to just bring them into the process to get their view on some of the other implications. Lawyers are very good with legal things, but sometimes the tax implications of specific planning, they need other advice. They're not experts in that field. So that's another thing to sort of bear in mind. So with the lawyer, you will work through some sort of planning considerations. So you've done that pre-planning, you kind of thought about things, and then here are some considerations the lawyer will probably put to you and you'll have to make decisions about in terms of those planning documents. who should benefit under your documents? Children, family members, charities. What are the income tax and probate implications of this plan? And I'll get to probate if that's a confusing piece. I'll get to that in just a couple minutes. What about the distribution of personal items? How's that going to go? Do your children get along if you have more than one? Is there something that should really be going to another family member because it's an heirloom? What does that look like? We have had situations in the past where there was not able to be resolution on distribution of personal items involving a painting actually being cut in half, sort of very Solomon-esque. So it is good to sort of bear that in mind. And oftentimes distribution of personal items ends up being quite a sentimental piece of the puzzle as opposed to a monetary one. And also, does your plan work regardless of the order of death? So this question is particularly pertinent in a blended family scenario where there are children on both sides that are not children of both individuals in the couple. And so the sort of distribution structure and planning can be impacted by if one person passes away first versus the other. And also you want to make sure that you're not sort of doubling up on things if you didn't intend to. So that's something else to sort of take into consideration. Also, the timing of estate distribution. So one of the advantages of settling an inter vivos trust is that it's a lot faster than going through the probate process. It's immediate distribution. It's immediate as opposed to waiting through. The other question is, are you doing an immediate distribution, or are the funds going to be held in trust until X is met or for the lifetime of the beneficiary even? Who's going to be your executor and trustee, and then also incapacity planning. Very, very important to have those documents in place. Once that all gets finalized, you'll review drafts, you'll execute, meet with lawyer to sign up the planning documents, and then you get a bit of homework. So you get some organization pieces, notifying your executor and trustee of appointment. Usually good practice to check with them that they would be okay with acting in that capacity before you appoint them, but very good for them to know that they have been named in this capacity. And then assemble a planning package. Planning package is sort of a general term. There's not really magic to that as terminology, but it's really important that all of the key information is accessible and organized for your executor, that they can carry out their job. They don't get snafu'd or really stuck on a point because they don't have the information that they need. And then if there's any other sort of extraneous documents that you want to involve in that, if you wanted to put together a letter of wishes, if you wanted to do a memorandum of articles, those are documents that are not binding in the same way that a will is, but are really further instructions for your executor and trustee in terms of how things operate. And then you're done. So then you get some peace of mind, and then it's just review. So my recommendation is always to aim to review documents every 5 years, or if a major life event occurs in between. Does anything need to be changed? It's not even necessarily the case that you'll have to update the documents, but sometimes the law changes, sometimes tax rules change. So always good to just sort of verify and check in with the process, make sure those documents still actually reflect your wishes. So planning is an ongoing process. I wouldn't say it's ever like you can give yourself check marks and gold stars, but I'd say it is an ongoing process, and if properly maintained, can provide really wonderful peace of mind to make sure everything's going to be solidly in place. So I mentioned above that there are assets that can pass outside of your estate. So your estate is governed by your will, and it consists of what you own at the time of your death. So not included are investments in property owned in joint tenancy with the right of survivorship, insurance policies, pension plans, RRSPs, RIFs, annuities with designated beneficiaries on them. Those go directly to those beneficiaries. And also assets held in a separate inter vivos trust that you've already created. It's really important to know how all those pieces fit together. Anecdotally, my grandparents actually created a very comprehensive will in about 2001 and designated that half of the estate was going to go to my grandmother and the other half was going to be divided between my mother and her two siblings. And they did that. It was wonderful. And a year later, when it came time for it to be put to use, because my grandfather passed away, there actually was nothing to administer. in the intervening year, all of the assets had been transferred into joint tenancy or with beneficiary designations that really counteracted all these steps because everything went to my grandmother. Everyone gets along relatively well in my family, so they were able to really help and carry out those wishes. So my grandmother still gave her children 50% of the estate, but she didn't need to. She wasn't legally obligated to because that structure had changed. So it's good to know kind of how those pieces fit together. Make sure you're not contracting or working against each other, which can sometimes be helpful in having more than one of your advisors kind of in the room when you're having those discussions. Also describes why the process when the first spouse passes away is usually fairly straightforward. So not the case in all situations by any means, but oftentimes spouses will hold a predominant majority of their assets in joint ownership, or with beneficiary designations where they can't do that. And so when the first spouse passes away in a couple, oftentimes the administration is fairly straightforward. Always still good to go and talk with a lawyer because they can do some cleaning up on asset structures and make sure that you've got everything you need. But yeah, it's usually a much more straightforward process. And when we're doing planning, it's really for when the second spouse passes away, what's going to happen at that point. So just a really, really quick overview of who can make a will, what that looks like. So anyone over the age of 16 who has mental capacity can make a will. Capacity is a legal question, kind of beyond the scope of what we were going to talk about today. But lawyers can make that assessment when you sort of go in and do planning if there's any concerns about capacity. And then also, what happens if there's no will? So our legislation in British Columbia is called the Wills, Estates and Succession Act, which we lovingly call WESA. And it actually has a set of provisions. It is not, as clients sometimes think, the government who will get everything. There's a set of intestacy provisions, which just means you have no will. It sets a specific distribution structure and an order of priority for administration. So for most of you who are doing planning involving trusts, not having a will is not the option that you want to go with. But there is a backstop in place that would apply, and you don't get any say or control over that if you don't have a will. I'm not going to go over the mechanics of this specifically, just to say it is complicated and it's very recommended that you do work with a lawyer or notary if you're not doing any trust planning to get that effectively and properly structured. I have seen will kits before, and my recommendation generally is to go with a professional because they know what they're doing and they have done a lot of schooling for this and training as well. Okay, so once the will gets done, when someone passes away, what is the probate process? So probate itself is the process of proving the will to the court. So essentially what you do is your executor will assemble a package of documents, they'll provide them to the court, they'll prove that they've done a search for the will, they'll prove that they've notified everyone who needs to be notified, and they'll also provide the court with a copy of the statement of assets and liabilities, what the estate looks like. Receiving the grant of probate back from the court is the document that allows the executor to administer the estate. So before a grant of probate is received, the executor is not really going to be able to deal or access money in bank accounts. They won't be able to deal with anything with the land titles office. And so they're really limited in terms of what they can do and what they're allowed to access at that point. The sort of chicken and egg situation is that before they receive the grant of probate, they do need to pay the probate fees. So probate fees are about 1.4% of the value of assets falling into the estate in BC. And so those need to be paid. You get the grant, you're good to go. So probate does open the opportunity to wills variation action. So sometimes if that's a concern, there are other planning tools available. And other planning tools can avoid the probate fee. All things considered, though, sometimes probate fee avoidance itself isn't the only goal, and 1.4% can be sort of a smaller percentage given some of the other potential tax implications of planning tools. So, wills variation, this is what specifically allows for it. Essentially, what wills variation is in British Columbia, any spouse or child of a deceased individual has a right to apply to vary a will if they feel that they have not been given adequate provision for the proper maintenance and support of that individual. So what does this actually mean? That means a spouse, a minor child, an adult independent child, and an adult dependent child all have the ability to apply to vary a will. So this is particularly relevant if there's going to be either a child who's not receiving anything under a will, a spouse, if there's a very unequal distribution. It is a big area of litigation in British Columbia. We've got sort of the most expansive protections for that class of individuals in the country. So if there's any concerns about that, always good to obtain legal advice about it. Also, just a quick plug on powers of attorney. The will is kind of the big document that everybody thinks about. Power of attorney is sometimes overlooked. A power of attorney is also a very important document. There is two main types of power of attorney, general versus enduring. Enduring is the one you're really looking for with incapacity planning. It can be activated either immediately, which sometimes happens for spouses, or on a specific event happening. So a doctor assesses your incapacity. The alternative is really why, having a power of attorney in a planning document is great. The problem is that the alternative is a commutation application if you don't have a power of attorney in place and you lose capacity, which is expensive, lengthy, and it's a court application. Probate applications are done by way of what's called a desk order. So you just submit the documents to the court and they respond to you. You generally don't have to actually go and talk in front of a judge about things. Commutation applications, you do. So it's a much more comprehensive and overbearing process. Okay, so that was estate planning in a nutshell. You're experts now, so we can dive a little deeper into trust planning. So really for us today, the big key on trust planning we're talking about is disability assistance and sort of how those pieces fit together. So the Ministry of Social Development and Poverty Reduction has the Disability Assistance Program, which provides support for individuals who are designated as persons with disabilities. In order to be eligible, you need to meet financial eligibility, be 18, have a severe physical or mental impairment that's expected to continue for more than 2 years, be significantly restricted in your ability to perform daily activities, and require assistance from either another person, an assistance device, or an assistance animal. This is all probably things you're very familiar with. There's specific monthly payments. This is what's current as of the ministry's website at the moment. And there's really two criteria that are important for PWD purposes. One is income. And so there's income limitations based on how many persons there are in your family and whether they all have the disability designation. The other one that's bigger for estate planning purposes is assets. So the general asset exemption for PWD is for cash, personal property, which can be turned into cash, or personal interest in qualifying trusts. So for an individual or a family with one person who has a PWD designation, it's $100,000. And it's $200,000 for a couple who are both adults who have the PWD designation. I'm sure I don't need to speak about this, but we're in British Columbia. Life is very expensive. And so that's feels like a relatively low ceiling for what you're allowed to receive. There are some exempt assets under the regime. A home, motor vehicle, clothing and necessary household equipment, registered disability savings plan, and assets held in a qualifying trust, and I'll get to that. So 100,000 isn't necessarily the full limit, but it's very important to make sure that you are not stepping outside of those boundaries and potentially disqualifying an individual from any of their entitlements. So what is one solution? It is trust planning. So what is a trust? Trusts are complicated. There's a whole class about them in law school. But trusts are fiduciary obligations where a settlor or willmaker, so an individual who makes the trust, gives the trustee, who can be one person, multiple people, a corporation licensed to be a trustee, or multiple, property to hold for the benefit of a third party. And we refer to those as either the beneficiaries, or life tenants. The reason I use the word life tenants is that for trusts to operate the way they do because of some complicated trust provisions and rules that we don't need to get into, any trust needs to have residual beneficiaries. So essentially, when you create a trust, you create the trust for the benefit of Paul. You provide for Paul for his lifetime. The trust is allowed to deplete the funds if it needs to do so and does so. But if Paul dies and there still is money in the trust document, if it's whatever that trust document is, will provide where those funds are supposed to go if it's a fully discretionary trust. So that's why I'm using those words, beneficiary and life tenant. Property that can be held by a trust includes cash, real estate, securities, any assets an individual could own. And it is a separate legal entity. It has its own tax filings, distributions to follow, which are laid out in the trust documents themselves. So there's two main types of trust that you will hear about. The first one is called an inter vivos trust. Inter vivos means between the living. So it's created by a person while still alive, and they are alive, they settle a trust, they transfer assets into the trust. The trust documents outlines how those assets are supposed to be treated and who to pay them to, who the beneficiaries are, and provides a bunch of terms for the administration of the trust. There are a whole bunch of different types of inter vivos trusts. There's some income tax advantages if you're over 65 and settling a trust with either an alter ego trust for an individual or a joint partner trust for a couple. The other estate planning opportunity with an inter vivos trust is that it's a lot quicker to administer and doesn't have to go through the probate process. The probate process is one piece. The estate administration is a bigger piece. The estate administration generally takes sort of 12 to 24 months in a normal estate. So it can be a lengthy process. One big caveat that I'll put here just as a note is that a person can create a trust if they receive an inheritance and want to maintain PWD benefits. There's a very short time frame. It's 3 months from the date they received the funds. But if planning was not done properly, to make sure that that individual continue to qualify for their PWD benefits, they do have this option to immediately settle an inter vivos trust. The other one is called a testamentary trust, which refers to that last will and testament. So it's created by a person under the terms of their will, which doesn't trigger until they pass away and the will kicks in. It transfers assets to a trustee to be held for the benefit of an individual under conditions outlined in the will. The trustee can be the same person as the executor or a different person. The trustee owns the property of the trust. The beneficiary does not. The trust becomes a separate taxpayer, and it's a great option in terms of preservation of PWD benefits. So there's a further distinction in terms of trust. So those are the two sort of big types of trust. And then there's a distinction between how the trust itself operates. So there's what's called a discretionary trust and a non-discretionary trust. So under a discretionary trust, the trustee is given the full discretion as to whether or not funds, income, or capital are paid to a beneficiary. So at the end of the day, they look to the terms of the trust, they carry that out, but it's their decision. The beneficiary can't say, full stop, I want all the money, or I want X amount of money for this. The trustee reviews requests and decisions and those sorts of things and follow all the trust terms, but they're given discretion as to how the funds are paid. So there's not any, the beneficiary is never able to demand the funds, so they never vest or belong to them, which is an important piece of that. For a non-discretionary trust, the settlor or will maker gives no discretion to the trustee regarding how the funds get paid out. The trustee is obligated to follow the full directions given, and the beneficiary of life tenant can demand funds at any time, provided capable. Also means creditors can do that as well. So it's a less protected form of trust for several different reasons. So for the purposes of the ministry, discretionary trusts are exempt assets if fully discretionary, where the beneficiary has no control over how those funds are used. Non-discretionary trusts are an exempt asset as long as the amount contributed is not in excess of $200,000. If over, it won't be exempt unless it receives a specific exemption from the ministry. When I talk about discretionary trusts, I do want to reiterate that they are referred to by a bunch of different names. So if you've heard any of these names before, we're talking about the same thing. So it's also referred to as a Henson Trust, which is named that because of a decision out of Ontario, a disability trust, or a fully discretionary trust. Okay, so now you're all experts on trust planning as well. Excellent. You've done one course in one semester of law school. And so now we're talking about making the trust work. So one of the really big and very important decisions in planning is who is going to be your executor and trustee. And so who can act as executor and trustee is almost anyone. So the individual, if it's an individual, needs to be over 19. Trust companies can act, professionals can act. You've got a lot of options. So here are some key qualities to think about when you're looking at who might be a good executor or trustee. A really, really key one is the ability to spend the time and effort required to administer. So I mentioned before that administration of an estate itself takes 12 to 24 months. That's very standard and very normal. And it's a long time. It's a long time for individuals who may have full-time jobs or families or other things to deal with. So it's important to make sure you've got someone who's going to be able to take that on and not be overwhelmed by that. And with a trust, it's actually an even bigger commitment because depending on how old the beneficiary is, this trust could operate for decades. And so we've seen situations where there wasn't, unfortunately, an alternative structure built in when the trust was created. So the initial trustee is saying, I've done this for a long time and I'm retiring or I'm moving and not able to keep going with this. And they come to Souls Trust looking for support in that way. So disability trusts can have very, very long lifetimes. And so it's good to sort of bear that in mind. Expertise, age, relationship with a life tenant. Your trustee doesn't need to be an expert in terms of all the different pieces. They just need to be able to understand them. So they would probably work with a lawyer and with an accountant, but they need to be able to figure out and understand the mechanics of how they're doing it and following proper rules, making sure they're meeting all of their filing obligations and things like that. Age, again, is important to make sure they're not going to want to retire or might pass away before the trust is done being administered. And relationship with the life tenant is or beneficiary is important. I'll talk on the next slide specifically about siblings, but it can be challenging to have sort of one of the biggest trusted people be the trustee because holding the purse strings can create resentment or animosity from the beneficiary over time. And that's also the ability to deal with the life tenant without impacting other family relationships. So if it's going to create a strain or other things like that, it's a complicated structure for a lot of reasons for a lot of people. Having more than one trustee is an option. So you can have more than one person acting in this role and carrying it out together. Sometimes it can be helpful to share the burden in that way. You also don't have to have the same trustee as executor. You can have different people in those roles, and sometimes it can be helpful for them not to be wearing two different hats. Sometimes it can be helpful for them to have that continuity and carry on. So very factually specific on that. Potential conflict of interest. One of the challenges sometimes with family members, especially with siblings, is that they often would be the residual beneficiary of the trust. And so that whether or not it is true may create a perceived conflict of interest, and that might have an impact on other sort of family dynamics and relationships. Other key piece is residency. very much is not recommended to have a executor or trustee who's not a resident of Canada, because that can have some very negative tax implications for the trust. Sibling involvement. There was a great question that got put ahead of the session tonight about sibling involvement. And so I sort of specifically put that at this point, and if it doesn't answer your question, whoever put that question forward, I can maybe further expand on that later. But sometimes people will come and say, I want the sibling to be involved, I want them to do this. And so although one option is a sibling as trustee, placing them in that role of holding the purse strings can cause strain in a relationship. I've seen it happen. It's very unfortunate when it does. And so there are alternative options. So one is sometimes a co-trustee is better, where they're not the sole person making financial decisions. They could be protector of the trust, which is a specific role where they're sort of able to have some oversight as to trust accounting and potentially make decisions of replacement of trustee if they're not happy with the work that's being done. And then there's also unofficial advisor or consultant. So back at up at the top of this presentation, when I was talking about the letter of wishes, letters of wishes are great tools that get used a lot to provide additional context to executors and trustees for trust administration. And they can also lay out who are the key people, who should be talked to, or who should be advising if there are any questions about how the beneficiary is doing. So it's another role that they can assist with. Okay, so when we're talking specifically, we're boiling it down to the will with the estate plan on a discretionary trust. Here are some sort of key pieces to that. So the life tenant or beneficiary never receives the inheritance directly. So if you're creating a fully discretionary trust for a beneficiary in your will, those funds never go to that beneficiary fully. They never vest or belong to them. An unlimited amount of money can be held. The trustee should be aware or able to educate themselves of the limitations under the PWD regime, make sure that they are not going to be offside of any of that and accidentally disqualify the beneficiary from anything they would be entitled to. And if a beneficiary qualifies for the disability credit, the trust could be subject to the lower marginal tax rates, and a home held by the trust may qualify for the principal residence exemption if the trust is designated as a qualified disability trust. Qualified disability trust is through CRA and the federal government. The only really important, well, the qualified disability trust regime is great, and if you're wanting to look into that, I'll say you should look into that more. One really key piece, if you're doing a big comprehensive plan, is you can only have one trust per person designated as a qualified disability trust. So sometimes just when it comes to the larger plan, if you have an inter vivos trust and you're also doing a testamentary trust, or if there's multiple pieces, that is something to bear in mind of you can only have one per person. The discretionary trust is also great in that it cannot be claimed by creditors for debts incurred by the beneficiary without the trustee agreeing to the payment. That does happen in some exceptional circumstances. If there's, I think I've previously seen some sort of agreement where there was child support owing and those sorts of things. But there's trustee involvement. They don't have a right or a claim to those funds. It can also protect against sort of undesirable persons influencing the beneficiary to waste funds or giving money or assets away. And is protected even though a person may go through a personal bankruptcy as a beneficiary. So access to funds, the life tenant or beneficiary makes the request to the trustee as to funding. The trustee always considers the request, but they can say yes or no. They don't have to say yes. So my example of this is always the beneficiary comes in, they says, I need a vehicle, and here we go. This is the Lamborghini that I want. The trustee says, okay, I agree that you need a vehicle, but Lamborghini seems unreasonable. Let's maybe look at some other options, and we can take it from there. Usually, trustees will try and work out an annual budget, remit funds accordingly on kind of a regular basis over the course of the year. And also, the trust can often make third-party payments. So directly, they would pay rent, or they would pay a dental bill directly to a dentist or things like that. So the trust is more sort of involved in that capacity. I'll also talk about the RDSP. So the Registered Disability Savings Plan is a registered savings plan designed to assist individuals with disabilities. It's tax deferred, investment grown, and government grants. To qualify, this is the important part, the beneficiary needs to be under 60, but needs to also be eligible for the disability tax credit, have a valid social insurance number, and be a Canadian resident. There is a cap on this one of a maximum lifetime contribution of $200,000. So I'm almost done. Thank you very much for your patience. I will have you know, as Marcia mentioned at the very beginning, I did do my bachelor's degree in theater. So the fact that we're doing this on Zoom did protect all of you slightly from having to do some very involved audience participation, which I always enjoy doing. So I'm just going to really briefly talk about Solus Trust. So that's where I work and what I do. Some of the decisions that are involved, sometimes you don't have an individual, sometimes you do want a corporate trustee to sort of step in that capacity. So we act under all of these roles and also do get involved when things get a little bit messier with litigation and commitueships and things like that as well. But we will have some time for questions, but I think Marcia and Grant are going to take it away for the next portion of the presentation.
We are. Thank you so much, Ben. That was a lot of information. And I'm sure if we need clarification, we'll get some of that in the Q&A for sure. So thank you.
Sounds good.
And like Ben said, before we get to questions, I would like to introduce Grant Monk, who will give us some information on legacy gifts. I will join him for a bit of that presentation. After being called to the Law Societies of British Columbia and Ontario, Grant began his fundraising career in 1995, pioneering plan giving for the Canadian Cancer Society. He later led development programs for organizations such as the University of British Columbia. He was a former Director of Development for Pearson World College and National Director of Development for Ducks Unlimited Canada, and oversaw their $500 million campaign to restore natural wetlands. Grant established a private consulting firm in 2015, and one of his first clients was the BC Schizophrenia Society, working for over 8 years with staff and volunteers in the areas of fundraising, government relations, and strategic planning. We love working with you, Grant. Grant is currently a board member of the Canadian Association of Gift Planners Association Foundation and a life member of the Estate Planning Council of Vancouver. Grant has presented CAGP courses across Canada and spoken at national CAGP conferences and planned giving since 1996. Grant, thank you for being here, and look forward to the information you're going to present.
Thanks so much, Marcia, and hello to everyone across British Columbia tonight. I just wanted to first make a comment, and in terms of Ben's terrific presentation, and I'm sure a lot of you received additional information on the importance of having a will, what's involved in a trust. I think also to keep in mind the role that a trust company can provide in terms of acting as an executor and also being involved with trusts. There was a fair discussion that Ben had in terms of a will, and he spoke about beneficiaries and residual beneficiaries. And I'm sure many of you have been in a position when you've been going to a lawyer to have a will drafted. A question that you're asked is, who do you wish the beneficiaries to be of your estate? And, in most cases, the first individuals that are top in mind are family members, and a number of Canadians also consider organizations that have had an impact on their life. Could be the school that you attended, could be organizations that you've volunteered. And I know many of you have been involved as volunteers with the Society for many years. So we just wanted to give you a bit of an overview in terms of if you are planning on having your first will drafted or thinking of making revisions to your will, that charities such as the BC Schizophrenia Society and Foundation can be a beneficiary within your will. So let's just go to the next slide and talk about some options, if we can, Marcia, in terms of ways to give. Just so you know, while Marcia's putting that up, there's 3 different ways that you can actually make a gift in your will to support a charity. So it can be for a very specific dollar amount. So for example, you wish to give a charity $10,000. One term that Ben used through his presentation was the concept of a residual beneficiary. And if you think of an estate as a circle, a residual beneficiary will be receiving a percentage of the estate. So for example, in the will, you could state that I give to X charity a quarter of the residue of my estate. Something also to consider. The third option, which some people consider, is what we call a contingent beneficiary in an estate. And this is the case where the gift will only take effect in the event of the prior death of other named beneficiaries. So for example, if my spouse does not survive me, I give 1/3 of the residue of my estate to the BC Schizophrenia Society. So we may be having a few problems with the slides, but Marcia, I'm just gonna barrel on here. In terms of benefits to individuals in leaving a gift in their will to support charity, which we also call a legacy gift, because we're talking about the future support of an organization. Firstly, no reduction in your personal assets during your lifetime. This is a gift that would occur after your passing. And in many cases, it will support the future programs of the organization. So many of you may know that the Society's been around for more than 30 years. Many of you have volunteered for this organization, and many of you have received the benefits. If you want to ensure that other British Columbians will continue to receive the benefits of the Society, you may be interested in leaving a gift in your will to continue the mission of the Society. Also, there are specific tax benefits to an estate in terms of charitable gifts. And again, if you think of the estate as an overall pie, the less taxes that are paid by the estate, the larger net amount will be there in the estate to be distributed to beneficiaries, especially residual beneficiaries. So that's just a brief overview of a way to leave a gift in a will to support a charity. And I know, Marcia, you just want to talk a bit about, in terms of the Society and Foundation, if people are interested, how they can leave a gift.
Yeah, for sure. Thanks, Grant. So within the BC Schizophrenia Society, we have 2 entities, so 2 charitable entities in which you can leave a gift in your will. The first one is the BC Schizophrenia Society, and through the Society you can give generally if you just want to leave it to area of greatest need, and then we would decide where we would best use that depending on our priorities and needs at the time. Or you can leave that for programs and services, which would be used for our core programs and services. And if you were looking to want to leave gifts in your will to research, then you would leave your gift to the BC Schizophrenia Society Foundation. So those are the 2 entities. I think the slide is up on the screen, and you can see sort of the official name of each, the address, and the charitable registration number that you would need to give to your lawyer. So those are the 2 areas in which you could give in your will. I would be grateful for that if you did leave a gift in your will to us. And I think we have one more slide if we want to advance there. And just wanted to give you a little bit of information about how you can connect with us. So you can certainly connect with me directly. I can help assist and you and your lawyer with the correct legal name. So you will need that. So that was on the previous slide. The address, and of course, the charitable registration number, the designation of your gift and how you want to leave that. Can certainly talk to you about those and those options in more detail, and making an impactful contribution with your gift. So yeah, my contact information is there. I can certainly take emails or phone calls about any of this information and help along the way. But granted, I just wanted to just give a little bit of information about leaving legacy gifts and how that can happen, and that we absolutely accept gifts and wills. So just want to thank you for your time. And thank Grant for the information that he has provided. And I think it would be important now to get into some questions. And so we did indicate earlier that the questions, you can submit those in the Q&A box at the bottom of your screen. And we are going to start. We have some that were pre-submitted and some during the presentation. So let's get started. The first one we have is for Ben. Are there special considerations that need to be addressed when setting up a trust for someone who's 65 or older?
That's a very good question. So one of the things in terms of trust administration and the role of the executor and trustee is having an understanding of what the various sources of income and options are. So at age 65, the PWD regime ends and the OAS CPP kicks in terms of retirement. So in terms of the trust planning, the same tools are available. The beneficiary was over 65, so the other trust options are not really there. But it's just a bit of a change in terms of understanding the mechanics of where the other funds are going to come from and understanding that regime as well as the PWD one. So carries on with that.
Okay. Thank you, Ben. Next question is, when establishing a trust for someone who has a mental illness, can you set parameters as to how the funds are dispersed, i.e. $400 will be placed in John's bank account at the beginning of each month?
So this is a great example of something that we usually recommend to put specifically in a letter of wishes. So the trust terms, whether it's in a inter-vivos trust, whether it's in a will, are generally more kind of legal mechanics. So they will potentially speak to, I want the trust to provide for housing and education and medical services and things like that. They usually don't get into the specifics of exactly how much is going to be advanced and on what basis. And so usually that gets put separately in the letter of wishes. So it's, again, letter of wishes is not binding on the trustee, which is quite useful most of the time, because if you say, I want $400 to go into John's bank account at the beginning of the month now, and you die in 25 years, and inflation continues on at the pace we're seeing, $400 isn't really going to do quite as much as it would now. So when we're acting as a trust company, we always take a look at the trust document itself, and then we take a look at the letter of wishes, and we look both to what they specifically say and sort of the spirit and intentions in those letters of wishes, and so carry that out as much as possible. The other thing I'll say is we do have beneficiaries of trusts that have some pretty severe addiction issues, and so more creative or specific instructions can be provided on how to provide funds for that beneficiary in order to sort of protect them from using them for whatever their addiction is. So we've got one beneficiary that we provide funds directly to by way of grocery store gift cards. So that's what works for him, and that's sort of an option that when we stepped in, he's like, I want to do this. This is going to help me and be safer for me. So yeah, there's a lot of flexibility in terms of how funds get administered.
And of course, that has to be set before, you have to actually write that in the, yeah,
You do need to draft a letter of
yeah,
wishes to your
yeah,
executor.
yeah.
The other great thing about it is because it's not a part of the will, it can be updated without having to go back to your lawyer. So you just need to make sure your executor's got the copy, that it doesn't accidentally become part of the will based on the language you use. But it's really a great tool. And I like to say it's as helpful as it gives you peace of mind. So if it, like, I've seen very long letters of wishes, I've seen very short letters of wishes. If it starts being something that sort of is keeping you up at night based on making sure you've updated page 7, maybe it's time to simplify it a little bit. So
Perfect, thank you. Next one is for Ben as well. What happens to funds that remain in the trust if the person whose name it is in passes away?
yeah, so that depends on the type of trust. For us and what we're talking about fully discretionary trusts in order to continue on with these regimes. So the will or trust document itself will have specific parameters for what is supposed to happen. So the residual beneficiary or alternate beneficiary structure will be there, and the funds will go to whoever. So you as the will maker or the trust maker will get to decide where those funds go.
Makes sense. Okay, again for Ben, this is a bit of a longer one. Since I have no family or relatives or younger friends to administer a trust, I want to find a reliable Vancouver trust company that is affordable. I do not qualify for the Coast Mental Health Trust and my assets are more than 100,000. Is there a low income service for my son to write a will? Does he need a lawyer for this? If so, is People's Law School available for these services?
So I'm not sure if it's the son that's drafting the will or if it's the parent. So parent with a trust company, you can give me a call and we can chat and I'd be happy to sort of see whether we might be able to offer assistance. If it's the son looking to draft a will, not sure if it's something that the People's Law School would do or whether there might be another legal aid program available. But I think there are options, but I haven't specifically dealt with them.
Okay, thank you. Next one, if an individual receives a large sum of money, for instance, an inheritance, and they do have PWD benefits, is that why you would create the trust so that the inheritance, the money is sort of doesn't income or increase their income level?
Yeah, exactly. So basically what's happened is the way that the ministry treats it is there's an asset cap of that $100,000 for an individual. And they say, if you receive an inheritance and within 3 months you settle it into a trust, it won't count against that cap. If you don't, you have exceeded the cap and therefore it's going to affect your benefits. So again, 3 months, really quick turnaround. So it's important if that does happen, that that gets drafted right away. The good news is if it's through an estate, the estate's probably going to take 12 to 24 months to fully settle anyways. So you're not going to be receiving the funds right away. So don't wait until you get the money to go and actually talk to someone. Get the ball rolling on planning as soon as you can do that.
Makes sense, yeah, for sure. Ben again. My son has an RDSP with a considerable amount of money, 6 figures built up. I'm worried what will happen when he finds out that he has it. He doesn't handle money well. As soon as it comes in, he will spend it on anything handy. His mother and I stopped making contributions few years back because we feel that the money will be blown. Any suggestions?
Oh, that's a hard one. And this one did come in ahead of time, and I went and I double checked on the RDSP regime to sort of get an idea of what that looks like. It depends is the answer on that. RDSPs are quite specific in terms of how things go and who has control of them. And it depends on whether the adult, once they become an adult beneficiary, has capacity. So without knowing specifics, I can't really weigh in on that. But it may be worthwhile sort of taking a look at that and seeing whether you have the ability to designate somebody else as the sort of holder of that RDSP, or whether that's not an option. And honestly, I think one of the big things you could do is make sure that the rest of your estate does sort of get put into a trust specifically to provide for him, and make sure that he's not going to receive a larger sum of money again like that.
Okay, thank you. This is an easy one. Are we able to get a printout of your presentation for reference?
Oh, yes. Yeah, I can send that over.
Perfect. That sounds great. Thank you. Another one. After a parent dies, you are the next of kin and sole beneficiary, but not assigned the executor before the parent dies. Money is left in the banks or given to the PGT for a period of time now. What are the next steps to execute to get things going? Can a paralegal do this job to be cost effective?
So paralegals cannot. So essentially, you need to do an application for administration, which is a probate application where there is not a will. And it does need to be a lawyer who does that. And notaries are also not allowed to do probate application work. That is something that still is within, specifically within the legal profession. Depending on the firm you go to, they might be able to assign someone more junior who's more cost effective to do that kind of work. But yes, that is an intestacy. As a beneficiary and the sole beneficiary, you will be the recipient of that. So you'll need to get started on an application for administration and work with a lawyer on that. And the PGT will be able to transfer funds to the lawyer once that's all complete.
So thank you. Is the Qualified Disability Trust administered through CRA?
That's the designation, yeah. You would designate the trust through CRA. Yeah.
Good to know. Next one. I was told the maximum age of contribution is 50 for RDSP. It also mentioned strict criteria and mental illness was not on the government criteria. It was only given access to contribute to RDSP for a few years, then stopped. What reasons would this be for a limited time? Who do I speak to about this for ongoing ability to contribute specifically?
So RDSP criteria is set by CRA, so it's federal. So my best guess, and I'm not familiar with the changes back and forth, my best guess is it is a federal policy change happening, which is very frustrating. But best person to talk to about that would be your MP, because they're the ones who would be able to have a say. That's what they're there for in terms of representation for you. In terms of the contribution, a beneficiary can be up to 60. Government grant options stop at 49. So there's the two cutoff ages for that.
Perfect. This one I think will be for Ben and Grant. If my will is executed and a trust is ongoing for a loved one, how can the residual be left for BCSS? My hope is that my nephew will be supported throughout his life, but wonder how to articulate what's left over in the event of his death.
You want me to start on that, Ben? Give you a pause
Sure.
for.
Yeah, go for it.
You may, unfortunately, we didn't have the slide up, and I don't know if we can bring it up, the 3 different ways that you can, leave a gift for a charity. But if I understand the question correct, Marcia, one, yeah, here we are. So the concept of a contingent beneficiary is something that you may wish to consider. Just to let you know that from a charity's perspective, most gifts that are based on contingent beneficiaries actually do not materialize. But if there's, a spouse, a child that you want to receive the bulk of your estate, but if that individual predeceases you and you'd like it to go to a charity such as this society, I think that would be something very nice to do.
the two things I'll add to that, and the other area that I practiced in actually as a lawyer was charities law. So
Oh,
that's my other hat that I can put on. So there's two pieces, and one of the reasons that for what Grant is saying about residual beneficiaries not necessarily receiving anything is that typically when you're drafting a trust, you are providing that the trust can be used entirely for the benefit of an individual. So that means there doesn't have to be anything left over. And it's the sort of best practice for how to draft this type of trust. The other key consideration on that and the residual beneficiary piece is one of the advantages of, aside from being a wonderful altruistic person, of giving gifts to charity in your will is that there is a tax credit for your estate. But if it is a residual beneficiary, there is a limit on how long that tax credit is available. And that would not qualify. So essentially, if you are wanting to give a gift to charity and also have your estate receive that tax benefit, the specific dollar amount is the most effective way to make that happen, and is sort of the cleanest way for that to happen from the charity's perspective as well.
Awesome. Thank you both. We have a few more questions, but we have till 7:30. So if you guys are okay to continue on, we'll go through these as much as we can.
Yeah.
The next one. The only thing I have to leave for my son is a life insurance benefit, not assets or cash. Can I leave him as my life insurance beneficiary, and will this affect his PWD?
So part of the question, and this is always part of the question, is how much it actually is. So if it's not going to exceed the PWD amount, you're good, that's fine. If it is going to exceed the PWD amount, or if it's a very large insurance policy, you actually can create a life insurance trust. We have a few that we're appointed under. Essentially what happens is it's sort of similar to a will because, well, it's not similar to a will. You're creating a trust and then the trust holds the life insurance policy. And then it kicks in and starts doing its thing once you pass away and there's actual assets held in the trust. So you certainly can settle a trust that way as well. And it would probably be a good idea, depending on size of that policy, to look into whether that's a good option for you.
Great, thank you. What type of entities are available to administer trust if family isn't an option?
So trust companies are the big one. So trust companies are a bit of an odd corporate structure. We are all governed by under the same sort of umbrella governance of financial institutions. So in British Columbia, that's the BC FSA, BC Financial Securities Authority. So it's a very specifically regulated, audited industry. And there's a whole bunch of options in terms of trust companies and how that works and those sorts of things. There are other options. And so sometimes lawyers or accountants are sort of willing or able to take on that role, either in their professional capacity or in their personal capacity. The one thing I will say about that, as we have seen in the past, lawyers or accountants who were named as trustees who want to step down, is you're naming one person. You're not naming an entire organization. So if you name Solus Trust and this kicks in 30 years from now and I'm no longer with Solus Trust, that's fine. Solus Trust is still going to be around. There will still be people to step in and administer. There's a significant continuity of care in terms of that, that an individual just doesn't quite have. The other options are really sort of friends or things like that, but it is a big job. It's a big job for someone to take on over a long period of time. So that is something to take into consideration. Make sure that whoever you're asking or consulting really has an idea of what they're accepting or what they're kind of getting into. In my practice as an estate planning lawyer, I could always tell who had gone through the process of estate administration with someone before, because when I asked them who they wanted to be their executor, they had a lot more thought that they had put into it. Not to say kids are not a good option or sort of the default is not good. It's just, it is a really big job. It's a big job that takes a lot of time that most people don't have capacity to do alongside their daily lives. So.
For sure. Next one. If I sell my house and give the money to my sons before I die, do they have to pay taxes?
Oh, that's a good question. That's not as much a trust question. That's you wouldn't pay taxes, and the gift they wouldn't pay taxes on. So, well, I'll say you likely wouldn't pay taxes because it's your principal residence. So there is a capital gains exemption on the principal residence. There is a lifetime cap on that. So I'll go with likely no.
Okay.
Yeah.
Might be better for an accountant.
Yeah.
Yeah. Can you tell us how trust fees are charged?
Mm-hmm. So they're slightly different for estate fees versus trust fees. I'll go there. So in British Columbia, we have a Trustee Act, and it governs sort of appropriate and acceptable fees for executor and trustee services. And so they apply to anyone acting as trustee, not just a trust company. So for estates, your executor, whether it's your sister or whether it's a trust company, can charge between 0 and 5% of the value of assets falling into the estate, depending on complexity. So most estates end up being sort of in the 3 to 4, 2.5 to 3.5% range. And it's just a one-time fee for the administration work that they do. They have to pass accounts at the end of their role, so that sort of gets wound in there. For trust services, sort of depends on, it's going to vary significantly. So I'll say our rates tend to be lower than a bank affiliated trust companies would. Generally speaking, you're looking at sort of 3 fees for trust administration. There's a one-time setup fee. There's a annual administration fee, which is usually less than 1%. And then there's a capital distribution fee. So that would apply when there's distributions of capital made from the trust, wouldn't apply to anything income-based. The other thing I'll say, which we didn't really get into mechanics-wise, is trust funds are not just put in a checking account and left. They will be invested, they will be generating income on an annual basis, and that income is usually what's used predominantly to support the beneficiary, especially depending on how big the trust is. It's usually sufficient to cover most of the needs. You're not needing to dive in hugely to capital. Capital would be more, we're buying a house, let's do a huge distribution from the trust for that, or that sort of thing. The way we work is we do it on an individual basis. So if you're ever curious, you can reach out to me and I'd be happy to chat with you and put together sort of compensation agreements. The other thing about the trust model, I will say, just to sort of put you at ease, is trust companies don't charge for services until and unless they actually step in. So at least any of the trust companies I've dealt with, they don't charge anything on the appointment side or the appointment process. It's only once you pass away and the document kicks in, that's when the fees are. So reaching out and talking to a trust company, they're not going to charge you for time to talk to them.
That's really good to know.
yeah.
Yeah. Great, thank you. Doesn't a letter of wishes actually have to be submitted as part of the probate application, given it is oh, I can't say that word. Sorry, Ben.
Testamentary. So no. So
Testamentary.
the important thing, and this is what's very important. So letters of wishes need to have a specific statement in them expressing that they are wishes and not intended to be binding on their executor. So that was the piece that I was getting into, of making sure they're not testamentary documents. So that's the sort of the one side, and the other side is it's not binding on your executor, but because of that, it doesn't need to be submitted. And so the other piece of that is because it doesn't need to be submitted to the court, it's not a public record that anyone can look at and access. It's just for your executor and their eyes only.
Thank you. That. Are there tax issues or other implications to CPP, OAS, and GIC when someone over 65 has a trust set up for them?
I would say not necessarily. I mean, the big thing to bear in mind, and when they're over 65, it's actually that's the best time to settle a trust, an inter vivos trust, because the alter ego trust and joint partner trust, they don't get taxed separately. Essentially, they sort of get their way the government treats it as it's just you. It's an extension of you as a person. If you have a separate trust that you've settled, just like a family trust, it gets taxed itself. It's a separate legal entity, so it gets taxed in that way. So that would be something to bear in mind in terms of taxation itself.
Thank you. Is it correct that assets distributed via a letter of memorandum, RE assets, are not part of probate? And if a physical asset is given to someone via that letter, does the recipient have to deal with any tax implications? So an example, if we wish to have a vehicle, if we wish to leave a vehicle to a dependent with a disability, would the executor have to wait for probate to be completed, and would the recipient face a financial penalty?
So they would need to wait for probate to be completed unless they were a joint owner. ICBC, very sticky about that. So ICBC is another one in that category of banks and the Land Titles Office. They need a grant of probate essentially, or you to have submitted the grant. They're another organization that needs a high level of sort of security before they're willing to make that transfer. Technically, assets, even if they're dealt with by way of memorandum of wishes, they do fall in the estate. Like you're still giving your executor instructions as to how to distribute them, but they do fall within the estate. So anything that's of sort of a very high value, you might need to declare as part of your probate application. Probate applications generally don't list out specifics as to all personal items owned by an individual. They would declare more expensive items like a vehicle.
Thank you. We have 5 minutes left and we have a few more. I'll see how many we can get through.
Okay.
Hopefully, if not, then we can get some answers after. I'm not sure if this one you're going to be able to answer. What is the absolute latest RESP can be used?
Oh, an RESP. That I don't know.
Okay, that's more, yeah, for sure. So just to clarify, a person on PWD can hold 100,000 in assets. Is that the total allowed, including home and vehicles? Secondly, can an executor act on a letter of wishes if not included in the will?
So first question is, no, it's 100,000. The residence and vehicle are part of the exempt asset categories, so they wouldn't count against that, but double check those specific provisions on the Government of BC website just to get some clarity on that if you're confused as to what those look like. And then the second question, remind me what that was.
Can an executor act on
Oh,
a
yes.
letter of wishes? Yeah.
So yes, yeah, executors act on letters of wishes all the time. Only reason they would not be able to act on a letter of wishes is if it was specifically counteracted in the will. So if the will said, I want to leave my Van Gogh painting to my nephew, and in a letter of wishes, they said, I leave my Van Gogh painting to my brother, the will is the binding piece. So you'd need to do that. Usually a will say, I want my articles, which is like personal items, to be distributed in accordance with any memorandum that I leave, and then you leave the memorandum and they sort of go together, but it's guidance for your executor. So not binding on them, but usually they are carried out as much as they can be.
Thank you. If you have a RDSP and 100,000 in a discretionary trust, would he, I would think this is a family member, still qualify for his social disability payments since this all adds up to more than the government cap of 100,000?
So a discretionary trust, as long as it's fully discretionary and meets those criteria, does not count against the $100,000, nor does the RDSP. So they should be fine in terms of continuing to qualify.
Perfect. Is anyone eligible to be the beneficiary of a trust? Does the intended beneficiary need to agree or sign a form before a trust can be set up?
No, they don't need to agree or sign a form. They don't have to accept it, however. So basically what happens is very frequently trusts get settled or wills get made without people knowing, and they only find out when someone's passed away or when they're going to get a payment. So you don't need to. The caveat I will say to that, and I did see a Q&A question about bare trusts, is the bare trust and reporting regime. CRA has made a whole mess and a whole bunch of stress for a lot of people. The reporting provisions essentially required a bunch of information from a bunch of people. And they said, anyone who's a beneficiary under this type of trust, we need their information too. And then decided at the last minute they didn't need that anymore. So I will say currently, there's no need for them to know. CRA may introduce new reporting obligations that could change that. That they not necessarily, excuse me, that they would need to know, but you need to get information like a social insurance number and address from a beneficiary to provide to CRA. And then they would obviously know why you're collecting that information. The other piece of that was,
Is anyone
right,
eligible?
they can, yeah, anyone is eligible. You can have beneficiaries who are outside of the country, anything like that. They can choose not to accept it though. They could disclaim the gift or not, or renounce any rights they have to it. That's their right to do that.
Okay, thank you. We're at 1 minute, so I'm going to do one last question here. Is it normal practice to give one sibling one half of your estate and the other sibling on PWD the other half, but in trust? Does that cause conflict?
So half and half is very, like, that's an equal distribution. That's fine. Depending on capacity of the beneficiaries, I have seen some frustration about the fact that one child's portion is left in trust and the other is not, even where there's explanation. So one thing I'll say is it's oftentimes helpful to chat through, and I know this is not always the case and not always appropriate, but oftentimes it is helpful to chat through what the plan is for your estate with your children, because they're going to eventually they'll find out, and either you have the discussion now if you can do that and you can talk about why you've made that choice, or it happens later and you can't weigh in on that. If there is someone with PWD benefits also, it doesn't have to necessarily be a 50-50 distribution. If it's going to start being really radically different, like if it was going to be 75-25 or 90-10, that's when it's a really good idea to get legal advice, because that's when wills variation actions might come in, and always want to avoid that where possible. It's very expensive litigation, and so good to get advice. And sometimes it's appropriate to talk to beneficiaries and say, are you okay with this? Like, do you understand why I'm doing this for you and why I'm doing this for your sibling? But I will say again, only people that really matter for wills variation purposes are spouse and children. If we're talking about sort of siblings or nieces and nephews or that class of people, you can make the decisions you want. They don't have any rights to apply to vary a will.
Okay, great. Well, it is 7:30, actually 7:31. And I want to thank everybody for being here. I want to thank Ben and Grant. Unfortunately, we do have to end it. But we may, if it's okay, Ben, send you the other questions that we have. If we could get maybe some answers, that would be great. We could possibly send those out. For everybody that attended, thank you for coming. Thanks for supporting BCFS. Please be sure to fill out the post-event feedback survey. That's always important for us in doing events in the future. That is linked in the chat box. If you would like a copy of the presentation, please include your email address in the response. Ben, yes, we are going to be able to send those questions to Ben and send out the responses. So thank you, everybody. We do have a big event coming up soon, an announcement of our May event, and so be on the lookout for that and other events that we have coming up. So thank you very much and have a great evening.
Thanks so much.
Thanks, everyone.